live in the 6th Circuit area, okay? Which means Michigan, Ohio, Kentucky, and Tennessee. You might have to listen to this video until the end of it, okay? My name is Bijoux Ngwanda, as you know it. I am an immigration lawyer based here in DC. However, I do work with individuals across the country and around the world because we're dealing with complex U.S. immigration laws cases. If you're new to my channel, please go ahead and subscribe. If you are not new, welcome back. Thank you for subscribing, and please do not forget to hit the notification bell so you don't miss out on anything. If you enjoy the content, you go ahead and share, like, and don't forget to comment below. Also follow me on all platforms. Links are in the description box below. Let's get right into the subject. You know, my goal in removal proceedings is very simple yet complex. Simple but yet complex. The goal is to get you the type of relief you're seeking. We know there are a lot of type of reliefs people seek in removal: asylum, withholding of removal, CAT, Convention Against Torture, cancellation of removal, adjustment of status, VAWA cancellation. We have cancellation for lawful permanent resident as well. And then sometimes we just go to after the fact, right? We try to ask for stay of removal, or we find other alternatives to remove you if you can adjust status with USCIS. And sometimes if there's really nothing else to do, then we can find out whether or not we can ask for administrative closure, so to allow you some time so that you can later on find something to work out with USCIS. We have asked administrative closure before for humanitarian reasons, even when we did not have a specific petition pending with USCIS. But listen to this very carefully. If you live in those 6th Circuit area, right? In those areas, unfortunately for them, you cannot ask for administrative closure. So meaning that the case is weak and you don't want to dismiss the case because you cannot pretty much have a work permit and you don't have any other ways to work. Well, but unfortunately in those 6th Circuit area, you cannot. Why? Because according to them, you have to ask administrative closure. Basically, the judge does not have the power to grant you unless you have a I-601A, okay? Provisional unlawful presence waiver, and you want to try to get out and get visa from outside. That's the only time they will close your case, pretty much administrative close it, to allow you to get that unlawful presence waived and get your immigrant visa from outside. Other than that, really the 6th Circuit has difficulty. So what can you possibly do? Well, if they offer you dismissal and you feel like the case is weak and you really don't want to waste your money and your resources to fight in BIA and federal court, then maybe the dismissal can be something that you can try to get. But you know, case by case basis, depending on the facts of the case, that's how we advise, okay? So, but this is really what I wanted to talk to you about, because we had a case yesterday, but that case was in Baltimore, so we got it dismissed because the ICE opposed administrative closure, right? So we couldn't go with administrative closure. But when you're trying to dismiss your case, when you're trying to ask for administrative closure, you go with the matter of Avetison and the matter of Cruz Valles. Those are the matter that has been really reinstated after 2017, right? Because they fought it and then it came back again to life. So yeah, if you live in those areas, Michigan, Ohio, Kentucky, Tennessee, you're pretty much out of luck, unless you can really argue strongly. But just know that you will face a lot of opposition from the ICE attorney, okay? Yes, that was immigration with Bijoux Ngwanda, your one and only immigration lawyer in the DC metropolitan area. Until next time, bye-bye.